But welcome all to this webinar. Allow me to just present. All right, so welcome to today's webinar. We are celebrating Data Privacy Week that is being conducted from 26th to 29th, or rather 26th to 30th in some other jurisdictions. The title of our webinar is Lived Reality of Enforcement of Kenya's Data Protection Act. So the objective of this webinar is to examine how the Data Protection Act 2019 is being enforced in practice and to get some perspectives from guys who deal with the enforcement, or rather the compliance with the Data Protection Act, and to just to have a conversation on how regulators and DPOs and data governance policy experts are empowering data subjects to take control of their data. So without much further ado, let us begin. So my name is Calvin Mulindwa. I am a research assistant at the Center for Intellectual Property and Information Technology Law. I work under the Intellectual Property Department and the Data Governance Department. So about CIPIT, we are a center, a research-based center and training center based at Strathmore University in Nairobi, Kenya. Our work focuses on the intersection of law, technology, and innovation across Africa. We provide evidence-based research, capacity building, and policy engagement on issues surrounding data protection, artificial intelligence, digital rights, and IP law. So Data Privacy Week. So just to give you a bit of context of what this Data Privacy Week. So Data Privacy Week is an international effort to empower individuals to respect privacy, safeguard, and enable trust in processing personal data. The first Data Protection Day, which happens during Data Protection Week, was celebrated on January 28th, 2007. So it was a day to celebrate the signing of the Council of Europe, the convention, which might be considered the first convention on the regulating of processing of personal data. This is Convention 108. And it was the first legally binding international treaty addressing privacy and data protection. So since 2007, every year around this time, the whole world gathers to celebrate and to kind of raise awareness about data protection and data privacy. So this year's theme, 2026 theme, is Take Control of Your Data. So it's all about empowering people to understand that their online activities, from browsing habits, purchasing, health metrics, create valuable personal information collected by apps, websites, and devices worldwide. So some interesting statistics about enforcement in Kenya. So since 2019, the enactment of the Data Protection Act 2019, there have been over 15,000 registered data controllers or processors. The ODBC has resolved over 9,000 complaints. So 9,000 complaints by data subjects have been determined by the ODPC. As well, the ODPC has published 16 guidance notes on different sectors and subject matters. So allow me to introduce our panelists that we're going to have today. We have Mr. Francis Monyango. He's the Group Data Protection Officer at Old Mutual East Africa Group. He's an advocate of the High Court of Kenya and also a certified information privacy fellow. He's a pioneering privacy and data protection expert in Africa with over 10 years of experience advising on compliance, contributing to continental technology policy, digital governance frameworks. He serves as a Group Data Protection Officer at Old Mutual East Africa Group, overseeing privacy strategy, regulatory compliance across jurisdictions. He is a certified information privacy fellow, Europe, and also a certified information privacy manager. And he's also a holder of an LLM from the University of Nairobi. We are also joined by Ms. Esther Kago. She is the Data Protection Advisor for Medicines Sans Frontières. This is Doctors Without Borders in English. She's an advocate of the High Court of Kenya with extensive expertise in legal compliance, risk management, and data protection across sectors such as finance, technology, healthcare, humanitarian operations. She embeds data protection into operations through policies, contracts, audits, breach response, and international transfers, while being well-versed in Kenyan, African, Asian data regimes, GDPR, and sensitive health data handling. We are also joined by Ms. Winnie Ngigi. She is the Data Protection Officer at Jubilee Insurance. She is a leading privacy and technology policy professional with over 5 years experience advancing data protection, digital rights, and responsible technology governance across Africa. She's also a trained lawyer, a certified expert, fellow of information privacy, certified information privacy manager, and certified information privacy professional in Europe. She currently serves as a data protection officer at Jubilee Insurance, where she designs, implements privacy programs, ensures regulatory compliance, manages risks, and supports cross-border requirements in sectors including insurance, banking, fintech, healthcare, and faith-based organizations. We are also joined by Mr. Mustafa Mahmood. He is the co-director of Namati Citizenship Program in Nairobi. He has over 12 years of experience supporting community-based paralegals on citizenship rights, inclusion, statelessness, issues in countries including Kenya, Bangladesh, Jordan, and Myanmar. He previously served as program manager at the Nubian Rights Forum, leading a team of paralegals to assist the Nubian ethnic minority in securing citizenship documents, and received the 2021 Good ID Award for Inclusion. So let us jump straight into the conversation that has brought us here today. So to begin with the first round, which is kind of to give us more information on what enforcement of the DPA is. And the first question is for Mr. Francis and Ms. Esther. Hello, Francis. So the question is, from your experience, how is Kenya's Data Protection Act being enforced in practice as opposed to how it is written on paper?
Thank you very much, Calvin and Cipit, for this opportunity and also for this question. I think that in Kenya, we've gotten law and it's not, and we are, as a country, we have been able to enforce it thanks to effort, the good work by the people at ODPC, because now enforcement is being taken seriously because people know that there will be consequence. That's not the ideal way. Ideally, people should be able to just follow the law, but you know, human beings, they need to be triggered to adhere to certain rules and norms. And that has been the case for the Data Protection Act. Looking at like decisions from the regulator, ODPC, as of 2025, according to a report by DPGSK, the Data Privacy and Governance Society of Kenya, they state that there were 96 decisions by ODPC published. So there are definitely more, but the ones that were published in the website were 96. In the year 2024, there were 50, I think it's either 51 or 54 decisions. And you can see what, also moving from 54 to 96, it shows you that there has been an increase in people reporting or people seeking redress to ODPC. And that also shows that there's two things: awareness of the system, awareness of the law and their data subject rights and their right to redress. Secondly, trust that action will be taken, and trust in this system of redress that has been created by the Data Protection Act. So in terms of compliance, this is forcing entities to now put in place systems to ensure compliance. There are some, like now I'll speak about the financial services, and I know Winnie will also talk about it later. In the financial services sector, before even data protection, they had systems of confidentiality. And now when the Data Protection Act and when cybersecurity laws came in force, it was more of enhancing an advancement of already existing obligations of trust and confidentiality into now embedding it into now these laws that probably have evolved the confidentiality requirements to be more than just customer confidentiality, to now have data subject rights, like you can request for information, you can request for restriction and such and such.
Thank you so much for your answer, Francis. We can move on to the second question. This question is for both Mr. Mustafa and Ms. Winnie. I guess Ms. Winnie can go first. What has changed the most for data subjects in Kenya since the Data Protection Act has come into force?
Thank you, Calvin. if you can see me.
Yes, we can see you.
Yes, so from my perspective, what I'd say has changed is we're now dealing with data subjects that are aware of their rights, and these are rights that just extend over and above their right to privacy, given that the Data Protection Act now gives them the data protection rights, the access, the rectification, and the likes. The other thing I'd say that has changed is they now know where to go in case there's a breach of their right to privacy or their data protection rights. Initially, I feel like it was a bit hard for you to lodge a complaint or try and go after an organization that has breached your privacy, because the process then was a bit hard. You either had to do, I think, a constitutional petition, for the court to declare that your right to privacy had been infringed. But for now, with the ODPC in place, and also now people just think that actually organizations can be penalized, and it doesn't even matter the size of the organization. As long as you're handling data, then the regulator can penalize you. Then it looks like we're shifting from just looking at the law as it is and what it says to actual enforcement. Given, just as Francis has mentioned, so far by the statistics we are seeing, the regulator has issued about 184 compensation orders. In as much as for us who are in practice, we are seeing this as quite alarming, because it means anyone who's trigger happy can decide to come after the organization, but at least it signals that something is happening in this space.
All right, thank you for the answer. Mr. Mustafa, you may go ahead.
I was trying not to appear like a pessimist. As much as possible, I'll try. But I'd say the small fishes are really compliant. We have seen what has happened to Tala and other mobile lenders who are calling pastors and even your exes, asking them to compel you to pay their debt and giving them penalties. Betting companies, also we've seen them being given penalties for violation of data privacy. I am yet to see any government body being penalized by the Data Commission for violations. For example, in 2023, eCitizen database was hacked, and it was popular. It was out there in the media and all that. But the government did not come out and tell us the nature of the data leaks that had happened. If you look at, for example, the UN database when it was hacked around 2019, 2020, and 2021, former employees and any person that had ever interacted with the UN was informed that their database was hacked and the nature of data that was hacked, and if there was anything to worry about. All of us are either directly or indirectly subscribed to eCitizen. When eCitizen had a downtime and it was in the public domain that it was hacked, nothing. We were told nothing. And one of the rights of data subject is that we were supposed to be informed. Though I could also say that after the Data Protection Act was passed, there are some positive things that have happened. For example, in 2022, when the government was rolling out Maisha number, for the first time, the government thought about the data protection impact assessment, comparing it to Huduma number when it was being rolled out. So at least it makes the government to think about what are the possible petitions that can come out. So it's more like a stopgap measure to stop civil society from going to court, but at least there's something that is happening. But as I said, I am yet to see any government body being penalized for data breaches.
Yes, that is true. Government bodies are yet to be penalized for any breaches. Perhaps this year, maybe the year. So moving on to our round two of questions, I'd like to ask Ms. Winnie, how has your organization integrated privacy by design and privacy by default principles into core insurance processes?
So in terms of privacy by design and its integrations, I'd say from where I see it, it's not something that as a DPO or as a privacy professional, it's not something that comes later on in an organization's processing activity. What I've seen happening and what we've also tried to do here internally is to ensure that as the data protection office, we are involved from the onset of any project. So we sit within project meetings, we sit with the developers. Once an idea has been proposed, for instance, by the business team, then they approach us. We have the first initial discussion to see how privacy could come in, so that to ensure by the time a product is going to the market, or by the time we're implementing a system, then we put in place the necessary measures to ensure that an individual's rights have been protected. So I think why it starts is asking the right questions. For instance, why do we require data? How much data do we require from an individual to fulfill our specific purposes? Also, the other thing we check is the necessity and proportionality. Is this new process necessary? Can we keep relying on the process that we've had before and they've been working? Can we just maybe tweak something within the process, but ensure we're not doing something that is excessive? The other thing is always using DPIA as a tool of embedding privacy by design. So by using DPIA as a tool, you're able to integrate the privacy principles from the onset of the project or from the onset of the product. You're also able to assess what are some of the risks that an individual could face. And what we'll be looking at is ensuring that we're not just limited to the right to privacy or the rights that are in the Data Protection Act. We're looking at it holistically, because you could come up with a product or you could come up with a system that in one way or the other could maybe discriminate someone, could disadvantage someone in one way or the other. So try and look at it holistically.
All right. Okay. The next question would be for Mr. Francis. And the question is, what strategies have you found effective for incorporating AI and emerging technologies into data governance frameworks while maintaining robust privacy safeguards?
Thank you so much for that question. Now, when it comes to AI, it's more of when a business is trying to embed AI into the systems, it's there to probably enhance a process that is existing, or let's say to solve a business problem that in service delivery to the customers. So it's more of understanding the customer journey or the processes that involve now processing of personal data, and then now doing DPIAs, and it's pretty much working with the team deploying the technology before they deploy it completely. Borrowing so much from what Winnie has said, but there's also the element of understanding what the business is trying to do and then advising them beforehand, and then also having conversations with the vendor. If let's say it's an outsourced solution, or if it's something which has been built by the let's say robotics team or the digital team, now you work with them step by step in developing this, because they'll do a prototype and then probably share with you based on the governance structures that you have that require the involvement of the DPO in the developing technologies that will process personal data at one point or the other. Then based on that, you advise them on the required safeguards that should be in place, and then now they go back and put in place those safeguards and such. When it comes to compliance, especially with the AI, there are several things. There's the element of governance, where already existing governance structures can enable compliance from the word go. But now, if the governance structures do not enable this, you find yourself in a situation where you're chasing after people after they are done with an entire project which they've been working on for 3 years. And at that point, whatever solutions are going to to be suggesting will be bandages. It'll just be bandages, like they're not solving the problem, they're just trying to salvage the situation. So there's that element of the governance in the organization needs to really be open to the considerations and advice of compliance, in this case being privacy. And while at that, work in building now privacy by design in these AI solutions. And that now also applies with the outsourced solutions. Can request for the DPIs that they have done, review them against the safeguards that are in place, ask yourself now the hard questions, have conversations with the business or the head of the business and into the considerations. This risk is there. What are we doing to mitigate it? What happens if such a thing happens? And some of these risks. Then when it comes to technological risks, there are very many other factors that come in play. I think in the tech space, and probably Mustafa acknowledges this, political risks also touch on technology a lot. If you're deploying a solution that is very digital and then you are operating in a country where there's an internet shutdown, so what happens to what you're supposed to do on the in terms of now data subject rights or customer needs? So do you have BCP, business continuity plans in place and such and such? So you think about risk from a wholesome way, and then now the compliance safeguards in place so that whatever you're deploying ensures that it meets the requirements of the law. But also there's the element of AI being a very evolving thing. So whatever AI solutions were being deployed 2 years ago, right now probably it's something common, and the digital team is now proposing something new and something new. So you cannot sit and relax, but you can create a governance structure that can enable you to work with them, with the digital or the innovation team as they on the go, so that you do not have clashes later on when they're trying to deploy and they're telling them no.
All right. Thank you for that answer, Mr. Francis. The next question is from Mr. Mustafa. From your perspective, have the communities you have worked with understood the importance of protecting their personal data?
That's an interesting question. The mandate of civic education lies with the government. Unfortunately, the data protection aspect itself is not a priority of anybody in terms of awareness of the public. Even if you look at the adverts, there is no government agency that is doing like massive campaign in terms of such data protection aspects. Like, let's just go with the bare minimum, M-Pesa SIM card, PIN numbers. You find our grandmothers going with their phones to the agent and saying, nitolee elfu moja. And some of them have been exploited. They withdraw more and give them whatever they want to give them. As basic as an M-Pesa PIN, now look at e-citizen account. Now that we're going to registration of birth in Nairobi and other parts of the country that are urban, all birth registration in Nairobi and other areas have been moved to e-citizen. Now imagine the vulnerability of e-citizen. How many people understand that e-citizen connects all the assets that they have, from land to cars and everything? And how aware are they that about the sensitivity of the protection of their e-citizen account? From a cyber cafe, once you've given someone access and you forget to log out, someone can easily manipulate your system, especially when they can even tell you that there's an OTP that has been sent to your phone and you don't know that there's a transfer that you're doing. So I think the level of awareness has not yet reached the minimum threshold from the people who are, we could say, the elitists in the community. They still don't know the sensitivity of data protection. And in now that we are moving to digital public infrastructure, it's very, very important that we do massive awareness. And this massive awareness, as much as it's a government responsibility, with this Data Protection Week, we should really push other civil society, from those who are working in the health sector to those in the education sector, that it should be all of us holding hands to make this awareness, because we are very trusting. As Africans, we are very trusting. But unfortunately, we are living in a manipulative society that people could easily manipulate you and violate that trust that you've given them. And with such violation that can be very hard to repair, it's very hard for us to repair data loss, especially when eCitizen has everything that you have. In this movement of digitalization, I think we've not done enough in terms of our awareness. But some of us, we are really pushing with the communities that we work with to try and tell them, with eCitizen, it's very, very sensitive data. Do not leave the cyber without logging out, and making sure that you do not save your passwords.
Thank you so much for the answer. Indeed, it will take all of us to educate all of us. That's what I like to say. I'd like to pose the next question to Miss Winnie. What emerging challenges have you seen in assuring lawful processing on data subject rights?
Thank you, Calvin. So in terms of challenges in enforcement, give three. So the first one I've seen most organizations struggle with, even when you look at the determinations by the data commissioner. So the first one is on consent and consent management. For example, you find maybe an organization has an event somewhere. So they've come up with a brilliant notice, but in that notice, it tells you by entering this event, you have consented to the event organizers using your images or your videos or any footage for purposes of marketing. But if you look at what the Data Protection Act requires, is consent has to be specific, it has to be written, it has to be unambiguous. So most of these notices actually fail in terms of what a notice under the Data Protection Act should look like, because they don't even disclose who the controller of the data is, how long will they retain your data, will there be any transfer of that data? And also, given that if they want to use that data for marketing or for commercial use, then consent has to be very specific, and it has to be tied back to a specific individual. So when you have a notice that is just general, then how do you tie it back to which individual it is who's requesting for their data to be deleted or who is withdrawing their consent? The other thing is on data subject rights management. For most of organizations, this is something that is new. So you could find that you don't have proper systems in place to ensure you're capturing the request as and when they come in. This could mean that there's a likelihood that you're going to miss a request once it comes in. Or if you're in the process of handling that request and maybe it came in through, say, the customer experience or the customer service team, if that team has not been trained on how to respond to data subject rights, including the timeline, then it's possible that if someone was handling that particular complaint or that particular request is away on leave, then that process falls off. So once it falls off and someone has already made that complaint, maybe you've become aware of it because a notification has been made by the regulator that someone has made a complaint, or it's just at the individual's initiative, then it means those timelines could easily, it is easy for an organization to fail to comply within those timelines. There's also the issue on training. So how do you ensure that your trainings are effective? Because at the end of the day, in as much as you could have the best policies in the world, as long as your employees are not trained on what is the expected behavior in terms of how to handle customer data or even employee data, then it means it is very likely that at some point you're going to suffer a breach, you're going to suffer an incident, and this needs to be reported to the regulator. So going and telling the regulator that it is one of our staff that made this happen, then it already exposes you as an organization to regulatory penalties, because at the end of the day, the Act requires that everyone is trained. So when you do the training, it's also important to ensure that you have a record of the same. So have a record of when the training was done, how many people attended, including the specific names, as well as the date of the training, so that in case you're sued, in case there's a complaint and it is one of your staff that has made that happen, then you can always take the necessary steps to ensure this is remedied. There's even a case, I think it was against Safaricom, where they did produce evidence that one of the employees had actually been trained on data protection and they failed to follow the organization's privacy practices. So Safaricom was able to escape vicarious liability. So it also just goes back to documentation. If you don't document, it did not happen.
All right. Thank you so much for the answer. The next question is for Mr. Francis. In your experience, what are the most common pitfalls financial organizations face when handling cross-border data flows? And how can they mitigate these risks associated with varying international regulations?
That's a trick question, but I'll try to answer it. As I said earlier, you find that for most organizations, especially in financial services, there are obligations or these systems for they're already in place because of the statutory obligations and because of trust with the customer, the fiduciary relationship they have with the customer. So for most of them, especially international organizations, we worked on doing adopting instruments such as the binding corporate rules, BCRs. I've seen Rwanda enact a sample standard contractual clauses, and these were things that were suggested in the GDPR. So if, let's say, you have cross-continental operations or even international operations, if you have that, even if you're operating in a country that doesn't have privacy laws, yes, you find that internally your standards are at par with the rest of your co-companies within the group of companies. So that has been mainly the solution to this. And then now you find that with the local regulators within each country, you probably submit a copy of the BCR to notify them and to engage with them and tell them that as an organization that has been operating here for all these years even before the enactment of these laws, this is how we've been governing our cross-border data transfers. And then probably the regulator will have a few questions and then they will give you an approval. So it's been more of, you find that most of these organizations had things in place. So, and then now it's just about aligning whatever they had in place with local laws, which have come since 2019. Because if you look for the 2018, we didn't have as many data protection laws in Africa as we do have right now. So, but for organizations that are operating, let's say the ones that had roots from Europe, because of the European Directive of 1995, they already had in place systems that were enhanced, which they started enhancing from 2016 and to 2018 when the Data Protection Act the GDPR came into force. So by the time a lot of the African subsidiaries who are now by the time African countries are now getting data protection laws, which were pretty much highly inspired by GDPR, they already had in place systems that were pretty much compatible with the local laws. So there wasn't much conflict.
Okay. All right. Thank you for your answer, Mr. Francis. The next question is going to be from Ms. Esther Kago. From your work, what do you see as the biggest challenges? From your work, what do you see as the biggest challenge in balancing processing data, data subjects, patients' data, and strict compliance under Kenyan's Data Protection Act?
Hi, Calvin.
Hello, how are you?
Fine, thank you. Thank you for your question. So
Yes.
the challenges vary from one industry to the other. It depends with the organization and the industry that the organization is. But the challenge comes from balancing the data subject rights, balancing with the principles, and also meeting operational and organizational needs, because it depends with maybe the mission of the organization and what their core mandate is as an organization. And you find, like, let's say for organizations that are in profit, they will tend to prioritize profit more compared to actually balancing the processing of this personal data. Vis-a-vis, when you compare organizations in the humanitarian sector, they will again also prioritize the actual need than even the data subjects themselves. So you find that you need constantly to remind organizations that they need to learn how to integrate data protection principles within their daily work so that you can be able to balance this. Then again, what I always advise is the best thing to do is to put yourself in the data subject's shoes. Would you be comfortable if your data is being processed the way it is being processed? Would you prefer if organizations are more compliant, or would you prefer if organizations did not really care about how your personal data is being handled? Yes.
Okay, I see. Okay, thank you for your answer. The next question is for Mr. Mustafa. So from your experience critiquing systems like Huduma Number and Maisha Number, what are the biggest challenges or gaps you've encountered in how Kenyan authorities enforce the Data Protection Act?
Still, with fear of appearing as as a critic, that question has put me in a very nice spot. But anyway, the first one, Huduma Number 2019. By the time Huduma Number was being rolled out, we didn't have a Data Protection Act. So the Huduma Number, there was no Data Protection Impact Assessment. And it means that we didn't know the entire system. Actually, we knew that they are not designed the entire system with the protection aspect. After going to court under the consolidated petition of Nubia Rights Forum, Aki Center, Kenya Human Rights Commission, and the Kenya National Commission on Human Rights, the consolidated petition 56, 58, and 59, is when now the government of Kenya passed the Data Protection Act, which was a bill for very many years. And you see that the intention was basically to just tick the boxes. Now, go to 2022, we rolled out the Maisha Number. For the first time, the government published the Data Protection Impact Assessment. If you understand Maisha Number very well, you know that it's a five level system. There's at birth, there's at 18, there's at education, there's Maisha card, and also there's the EID. And all these levels, not all of them had a data protection impact assessment. It was only done for two departments, for NRB, that is Maisha card, and Maisha Number at birth, which was a CRS. So basically, there are three components of the system that were not was not evaluated in terms of their possibility of data losses. When you look at also the Maisha Number registration, the aspect of consent was at registration you're giving is a bad practice. Those two concepts that I don't want my data to be shared. So the moment you say you don't want your data to be shared, you also say that you don't want to be enrolled. And it's not like a privilege of saying in other countries like the US that people say, I have the right to not be registered. In Kenya, an ID is the right to have rights. So if you look at that and compare it to saying that I don't want to enroll, in Kenya, you don't have that privilege. So when I look at Huduma number and Maisha number, there were a lot of flaws in terms of even looking at the aspect of consent at registration and consent at sharing the information. So even when we transition to Maisha number, we still have the data from Huduma number that we knew had a lot of flaws. The data has never been shredded. There is no information on how it will be discarded or something like that. Huduma number and Maisha number, you could see a bit of remedy. During Huduma number, there was no like a clear data controller because it was a secretariat that was convened by Ministry of Interior, Ministry of ICT, and it was loose. No clear subject to that in terms of who is the custodian of data. For Maisha number, you can know through the different levels. You'll know that for if birth registration has been messed up, you know, I'll have to go to civil registration. For Maisha number, if it's messed up at the age of 18, you know, you can go to NRB. So at least the data controllers at different levels are clear now. So I think there's a bit of win-win situation, but there's still more in terms of to be done. And I'm just celebrating the small wins that we've had between Maisha number and Huduma number. But yeah, those are my takes.
All right. Thank you so much for that answer. I'd like to inform all the attendees we're about to enter our final round of questions with our panelists. I am inviting you to put your answers or your questions either on the chat or the Q&A session that we can discuss after we are done with the final round. So to begin with the final round, Ms. Esther, what are the key lessons you have learned from dealing with sensitive personal data in your sector?
Thank you, Calvin, for the answer. The first lesson I learned early on, when I first dealt with sensitive data, don't be so quick to rely on consent as a legal basis. It's one of the weakest justifications you can rely on, because yes, it empowers the data subject, but you need to think long term. What is the overall effect over what is the overall effect over the personal data that I am processing? And sensitive data, it is so sensitive because the biggest risk is on the data subject and on the individual. So you need to really ask yourself, do I really need this all this personal data? So another important lesson is it's very good to make sure that you minimize the collection of your sensitive data. If possible, always try to use aggregate data or completely remove any personal identifiers from your personal data if you're making an analysis. But in the event that you have no choice whatsoever, that you need to rely on the sensitive, you need to process the sensitive data, then you need to put in place really good security measures. And also keep in mind that whoever loses is the individual. Systems aside, any risks to the organization, the biggest loser is the individual whose data we process. Then another, and lastly, the key lesson I learned is no matter how many controls you might put in place as a DPO or as an organization, culture will always beat the internal controls you have. So it's good to make sure that you try as much as possible to train and embed data protection into the staff and into the people who are processing this data, so that they can be able to pause and think, what would be the cost if this personal data was to be breached, if it was to be mishandled. Thank you.
Thank you so much, Ms. Esther. The next question is from Mr. Francis, and the question is, are there any lessons or challenges you have experienced in harmonizing group-wide policies? Sort of related to your last question.
Definitely. Each country is a sovereign state, and the way they enact their laws, they try to exercise that sovereignty. And in that, you notice that there are different nuances when they're trying to enact data protection laws. So in certain countries, depending on their, let me call it the national psyche, they're heavy on security and authorization by an entity. You find that Kenya is quasi authorization by a regulator. So it's for you to decide on which legal basis or which transfer basis you're going to rely on. In others, it's as long as it's pretty much whatever is in the GDPR chapter 5. They went and copy pasted that and put that in their laws. So when it comes to like privacy compliance from a cross-border point of view, there's that element of understanding the national laws, and then the common points of divergence, and then now giving comfort to advising the in-country team to ensure that they give comfort to the national regulator that they will be compliant and getting the required approvals where it's required. So if I find that in countries such as Rwanda, you need to get approval from the regulator for certain processes. In Kenya, other than registration, we not even ODPC don't even have such forms. So it's because they do not anticipate a situation where they will be giving you approvals for certain things. So it's about just balancing those aspects and ensuring that at the end of the day, business continues, because we do this to ensure that business can still sell and make money.
All right. Thank you for your answer. The next question would be from Mr. Mustafa. So looking ahead, based on your professional observations, what reforms or additional measures do you recommend to strengthen the enforcement of the Data Protection Act in the context of expanding digital ID initiatives in Kenya?
I think we need to move to the capacity building from the government to even the agents. You'll find that some of, like for example, birth registration, civil registration department works through agents like chiefs, nurses, and all that. So I think the Office of the Data Protection Commission should invest a lot in terms of building the capacity of these government officers who are the custodians of the data, and their agents that are going to collect this data first. Secondly, we need to do massive awareness in terms of data protection and capitalize on whatever safeguards we already have and make sure that these safeguards reach the masses in terms of what are the possible redresses. Like, for example, basic things when government are designing systems like digital public infrastructure, are they thinking about data minimalization? If you reflect on Maisha Huduma number registration, they were on the other scale. They were maximizing all the data that they could get from the land holding that that you have, how many livestock you have, and all that. And if you look at such designs, you realize that the interests of such designs are not about the data subjects. It's more about data mining. So I think we need to build the capacity of government agents to think about how do you design systems that think about the best practices, for example, data protection, data minimalization, and even randomization of data. So we need to also look at how do we enforce aspects of consent during sharing of data. Unfortunately, we have not practiced this in terms of government being held accountable. The government have always been commercializing data, for example, through IPRS, which is now the Maisha Integrated Population Register. But do they give me as the data owner? Because I'm not only a subject, I'm the owner of the data. At what point do I give the consent for them to share my data? So one of the things that we need to build into our policies in terms of digitalization is to give data subjects the right to give consent when the data is being shared, especially now that we are going to build profiles and we don't know which profile is going to be given to commercial entity. And a good example, let me give you a good example. We have speed cameras that are automatically giving tickets and on Thika Road. One of the flaws is that sometimes you have given someone your car and the ticket is being given to you. you're the one paying a penalty for an offense that is not yours. So, like, because there's no data, there's no public participation when you're building such systems, people are just thinking that the only way to catch offenders is through the number plate. So, like, we need to integrate the aspect of public participation from the design level to even the enforcement level to see what are the possible flaws in the automation systems that we're doing. And we know that digitalization is the new industrial revolution, and we cannot move away from it. But we need to look at how do we build safeguards, especially when we have a very big digital divide. How do you build capacity when you have illiteracy and digital divide in the picture? So there needs to be a lot of investment in terms of building capacity to the people whose data is held in trust.
Thank you for that answer. Would be from Ms. Esther. What are some of the emerging best practices you've seen for mapping data flows and ensuring safe international transfers?
Thank you for your question, Calvin. So some of the best practices I've seen is, other than having the usual requirements, the SECs and it's good to make sure that you've done some transfer impact assessment. Those are some of the best practices I've seen being done. Assessing how will the data subjects be affected by the transfer, and also doing vendor due diligence, mapping out all the processors and sub-processors, ensuring that they meet the required data protection standards, and also making sure that you have data processing agreements as good practice. But my top one best practice is if and when you can, is making sure that you localize that data. Look for a good service provider, if available, that can make that will not make you maybe transfer your data. If the data can be processed within our Kenyan jurisdiction, then that is even better. But if not, make sure that you have put in place the required measures. Thank you.
Thank you for the answer, Ms. Esther. We have now reached our Q&A session. Hope Mutinda says and asks, interesting recommendation for a record of trainings done. Should we include the specific names of people trained, and what else would be necessary for that repository? Any panelist may answer this. It's not directed to anyone specifically.
So with trainings, it's more of you trying to meet the internal standard for confidentiality and for processing personal data. Remember, the law obligates you to ensure that there's confidentiality by your members of staff. So you're an entity, it's in your best interest that you have a record, and it should be, it's an internal record that upon a demand by the regulator, you will produce it to the regulator and show them that all our employees are being trained, although most of the time they just want the statistics. But internally, as an internal process, whenever you're doing anything, you want to know, okay, in this department of 40 people, who did all of them attended, even for the 3 who did not attend, who are they and why did they not attend? You find people on maternity leave and other justifiable reasons. But other than that, while you're doing it in names, depending on who requests for the record of the people who are being trained, you can decide now whether to share the statistics or the names. So like now the quest that was mentioned for the Safaricom case, all they need to say that, oh, this member of staff was trained on this particular date. This was what was part of the training. So, and they signed an attestation acknowledging that they've been trained and they understand their obligations in as far as ensuring that the organization is complying with the provisions of the Data Protection Act. So in such an attestation, it cannot be in an anonymized way. Definitely, you keep the record in people's names and their staff numbers.
All right, thank you for the answer. We have a question from an anonymous attendee, and he or she says, we look at government institutions and penalization. How tenable is this? How do we impose penalties that do not result in a backlash, like withholding information on grounds of privacy? Where do we find the balance between access to information and data privacy in public institutions?
Okay, I can take that, and the rest of the panelists can add on what I have left out. So when it
Please
comes
go
to
ahead.
balancing the rights of the data subject and also looking at what public institutions are doing and the overall mandate of the regulator in terms of giving these penalties, first you need to know what the core mandate of ODPC is enforcing giving the enforcements and penalties if and when they have a ruling and have findings that the rights of the data subject or the complainant have been violated. Then you also need to look at the legal basis. Why do public institutions collect and process information? Mostly it's because either they have been mandated by an act, by any law in Kenya, and from a data protection point of view, they mostly rely on public interest, provided that as they process the personal data, they are also again making sure to uphold the rights of the data subject. So it's a tricky balance. The organization, the public institutions need to be aware that even if you're a public institution, the information you're collecting belongs to an individual, and these individuals also have rights. Again, the data subject rights are still not very absolute. But however, individuals have the right to be able to access the information that they have whenever they want to, as long as the request is reasonable.
I can add something to that. Also remember that the Data Protection Act applies to both public and private organizations. So if we try to exempt them based on the fact that they're a public institution or a public organization, then it means we're also trying to exempt them from enabling the rights of the data subject. It means we are sort of allowing them to use data in whichever way they feel like they want to use it. For example, think about the USA and Kenya Health agreement. If it was not for the Data Protection Act, I am of the view that this data would have been shared without any proper safeguards in place, without even the citizen getting aware that their data has actually been processed. This also goes back to the Huduma numbers and the Maisha numbers. So it's also important that the regulator also goes after these institutions, in as much as, of course, it's political. There's issues to do with finding how the office is funded. Of course, there's a lot of political issues around that. But yeah.
I think I just wanted to add on that political aspect. The biggest hurdle that we have in terms of government being a compliant body is the fact that government never wants to be held in check. You've seen government cutting budgets for Kenya National Commission on Human Rights, terming them being rebellious. You've seen government going after judiciary, saying that they've become rebellious in terms of the way they've been giving judgments. So unfortunately, you might find that maybe the Data Protection Commission might want to tread carefully along that political line. And unfortunately, as the data subjects, we are the ones who get hurt because the government is the biggest data holder and data processor in the country. So we need to look at how do we hold them accountable, especially with the promotion of independence of such departments. To me, I think the biggest win that we'll ever have in terms of constitutional commissions is financial independence. The moment you depend on politicians to determine your budget, they will always curtail you down. So I think that's the biggest fear that I have in terms of compliance, in terms of that. But we've seen the government being compelled to issue data, for example, the time that we had the Olympics and as much as it's not the Data Protection Commission, the Office of the Ombudsman compelled the Ministry of Sports to publish information of those people who were going to participate in the going to attend the Olympics. So I think some of the commissions are bold enough to tread over those political lines.
Thank you so much, panelists, for that answer. There is a question here by Mungai Martin, and he asks, 5 years post-enactment, what measurable indicators beyond complaint numbers should stakeholders use to assess whether enforcement is generally transforming organizational data cultures in Kenya rather than simply generating compliance paperwork?
I know the experts in terms of compliance will jump in. I just want to say that I celebrate the 5 years by looking at the biggest violators, who are the mobile lenders. They were exploiting all the information that they could. In fact, the moment you subscribed, they could extract your book, your phone book, and do anything with it. But nowadays, you see that they do not extract a lot of information. Even the number of calls that we used to get have reduced. We have seen a lot of penalties that have been subjected to these mobile lenders, and to me, that's a big win as a citizen. If I could look at a win, that is one of the biggest that I could flag, but I'll leave the rest to my other panelists.
I know I'd mentioned the numbers of complaints by ODPC, but I think I don't think the numbers actually are as accurate as it is. Because if you look at every division and you look at the numbers, if you understand the number system, you realize that the complaints are in the thousands. But in terms of compliance, remember when I mentioned earlier, privacy compliance in certain sectors, it's not something that is new. It's an enhancement of already existing obligations. And if you view that compliance in terms of that, then it stops becoming a headache but it becomes just an advancement of how the modern customer is, because fiduciary relationships have existed even way before the computer was there. And there was the expectation of confidentiality and privacy at the time. Right now, it's just evolved to now give the customer much more power to ask for a statement, that's right to access, to ask for an objection. That's what Mustafa is talking about in terms of mobile lenders. You can object to them sending you certain communications to get right to information. So they're obligated to inform you on how they will process your information prior processing in compliance section 29. Restriction, you can restrict certain processes and such. So it's an evolvement that was going to happen anyway, because even the way we do business right now has evolved. The way we used to trade 25 years ago in the year 2000 is different from how we trade right now. Before you had to go to the shop. Right now, you just get into Glovo and order a pizza and it's delivered to your house. That's digitization. But in that digitization, this convenience involves the sharing of personal information. And hence, the sharing of this information, data protection laws introduce accountability in these relationships between the app, the service provider who's baking the pizza, the delivery guy who's delivering the pizza to you. So those relationships, the way they're being governed, that's where now data protection laws come in place. They were probably in place in some way silently under consumer protection rights, and those have also evolved over time. So I wouldn't say that it's just additional paperwork, but it's just the consequences of now digitization. You find that there are much more checks and balances in this age.
Thank you for your answer. Yes, Winnie, please go ahead.
I can also add a few things, and this is looking at it from the perspective of organizations, where what we are currently seeing is organizations are now trying to move from tick box to compliance. That is where we generally look at it as compliance paperwork, but these are discussions that are now happening even at the board level, where now we're seeing boards trying to get to understand what's the impact of data protection over and above the penalties, because if, of course, for most organizations, Kenya shilling 5 million or 1% of the turnover could be really pocket change, but there's a trust element to it. There's the impact that once your name is out there, that you suffered a breach or you're constantly on ODPC's radar because you've not complied with the provisions of the Data Protection Act, then your reputation automatically will suffer. And so for the board, this is something that is very key to monitor. What I've also seen that has happened as a result of this is most organizations are now evaluating their risk appetites. But we are moving from we can trade off between paying the fine and doing what we want to do, vis-a-vis trying to listen to what our customers want, to what our employees want. And also from in my consultancy days, what we also witnessed is most organizations are now actively reaching out to professionals in this space to just try and get them to help them in terms of compliance, whether it's the drafting of the policies, the data processing agreements, advising on consent frameworks. So I'd say it's not just the complaint numbers and increase in paperwork, but there's real work that is actually going into place.
All right. I have one question that I would like to ask the panelists, and it is, if you could change one thing to strengthen data subject control over personal data in Kenya, what would it be?
That's a very personal question you've asked, but I'll try and put myself, I'll try and wear both hats, data protection hat and data subject hat. So if I could change one thing, I would really emphasize on how organizations, anyone collecting and processing personal data, how they communicate to the data subject. And you find that most of these notices, they are quite technical. You're telling a data subject that, let's say, they have a right to portability, but what does that mean? Are you explaining to them how they can access their personal data in any format, and who can they reach out to? So if I could change one thing, it would be communicating in friendlier and less jargon-heavy tones, and also make it practical for them. You find that most of these people, most of the data subjects, they have access to devices. They can be able to read these policies, or they can be able to read how they can access or how they can exercise their personal their rights as data subjects. But now, what I would also do in addition to that is also consider these data subjects whose data we process but do not have access to devices or access to means where they can be able to easily read all these privacy notices or any communication material.
Mine will dwell more in terms of capacity building of the data subjects in the country. I think I'll encourage departments to invest in awareness, massive awareness, because with awareness, people will know what are their rights, what are the dangers in terms of, because we are moving to digital. We need the masses to know what are the dangers that are posing in terms of moving digital. And what are the possible redress in terms of when data leaks are happening, data losses are happening. So when people are well capacity built in terms of how to safeguard their data. I know of one campaign that is outside there, I think it's by Open Institute, it's called Feature Uchi. They've done massive campaigns in terms of data protection and what are the citizens' responsibility in terms of data protection. So I think there are massive campaigns and capacity building to the masses in terms of how do you protect your rights in terms of data protection, and what avenues of redress are there. And if we all could invest in simplification of these terminologies, data subject, breaches, data minimalization, and all those things, so that we explain it like to a 5-year-old.
I think for me, how I'd look at it is first, let's try and understand what control for a data subject looks like. Because when we say as a data subject, the Data Protection Act or the Constitution gives you, the Article 31 gives you a right to control your data and what data an organization has about you. But do you really have a real choice? Because think about the example I had given about the notices for events. In as much as, yes, the Act is telling organizations to be accountable, but as a data subject, do I really have a real choice as to what system an organization can use to process my data? Do I have a real choice in terms of failing to give my consent or refusing to giving my consent and not being discriminated or not having access to a particular service? I think we need to move from this is what the law says to a bit more action in terms of how an individual can take control of over their data.
I'm of the opinion that there's much more to privacy, and as Kenya, we've done a good job in terms of working on compliance of the act, and we have also an empowered citizen who understands their rights. And that understanding is it's a good thing, because that's the reason why these laws and these rights are there, for them to be exercised. So it's we're in a situation where now organizations are working. Compliance stops becoming a suggestion. It becomes a key component of ensuring that you're doing business. You're doing business while meeting the requirements of the law. And that I feel like that levels the playing field in terms of competition, in terms of service delivery. It levels the playing field because now you know that you have to comply because of reputational reasons and also pecuniary reasons. If all you're doing with your profits is paying out compensations and fines to the regulator, at some point, your business model will stop being attainable. So I think the Data Protection Act is a good law. There are certain things which probably need to be amended, but that's a discussion for another day.
I'd like to ask all our esteemed panelists if they could give us a closing remark, maybe a closing recommendation, anything they've witnessed, anything that would help us in taking control of our data.
So I get shy.
Yes. Oh.
I guess
yeah.
But for me, I think it's to just, I'll repeat what I said. The Data Protection Act is a good law. It's a progressive law. It's one of those business and human rights law. So it has it has the part for human rights, and then it also has the elements for business in terms of obligations for entities. Of course, I expect it to evolve, especially now in the late 2020s, as we're seeing with the evolution of AI. That wasn't a conversation in 2019 because we didn't know that, we didn't expect AI to have developed to what it is right now, and that's expected. Same way we couldn't have had this conversation 50 years ago because we did not have computers. Computers are not as mainstream as they are right now. So with the evolution of technology, definitely such laws will evolve, and there'll be an evolution of all these rights as well. So I think it's just having that resilience to be able to adapt to the changes in technology and the changes in regulation as required.
I like what Francis said about evolution. Mine is evolution of responsibility, and I want to look at how does government transform their thinking in terms of data protection? Because as much as we're digitalizing, are we really digitalizing our thinking around data, or are we looking at data as money? If we think about data as safeguards, we will look at how to protect it. But if we think about data as an aspect of money-making machine, we will try to maximize on that data as much as possible. So I would love to see the evolution of government's mind in terms of data, to look at it in terms of human rights centered, data protection centered, and not as a commercialization tool.
My parting shot is for organizations, do not feel like the act is here to punish you. Feel like our regulator is very, let me just say, easy. They're very easy to speak to get advice and on how to comply. But then again, at the end of the day, you also need to demonstrate compliance. So again, document, whether it's your trainings, your contents, your policies, ensure they're in a language that we can all understand. Not everyone can be able to understand jargon. So simplify it as much as you can, both for your external stakeholders, that's your customers, but also internally for your people, because at the end of the day, they're the people who will help you in compliance.
All right. Well, thank you, ladies and gentlemen, for attending this webinar. We hope that you have had a very insightful discussion from our practitioners into what goes into enforcing the Data Protection Act. Thank you so much for tuning. Please make sure to interact with our website. That is cipit. You can Google cipit and it will get you there, where we have blogs, podcasts, reports, and other informational material that you may also find interesting. So once again, to our panelists, thank you for coming and sharing your information and your experiences. Thank you so much for joining. Have a great day.